Recording started.
Hello everyone, this is Mark Schneider. Welcome to the FOJP 2015 Fiduciary Liability Webinar. Thank you so much for joining us. We like to do these webinars a few times a year on many different subjects, and we thought with the pending November 30th fiduciary renewal date for many of you, not all of you, but many of you, we would talk about fiduciary liability this year. Speaking today, we couldn't get you Donald Trump, but we do have Amari Williams, FOJP's Management Liability Associate, and we'll hopefully, as everyone knows, on all the management liability renewals. And also speaking with Amari is Michael Santaki, who many of you have met before. He's the Managing Director at Crystal & Company, and he's responsible for all of FOJP's management liability renewals, including directors and officers, fiduciary, employment practices liability, and other professional liability and errors and omissions type renewals that many of you have multiple of. Before we get started, just want to mention that if everyone could please put their phones on mute. And if you want to ask questions throughout the process or throughout the presentation or at the end, there's a chat box you see. For us, it's on our lower right-hand corner of the screen. If you could just type in your questions in the chat box, and we'll be paying attention to that, and we'll try to answer throughout the presentation. And of course, at the very end, we'll give you a chance. We'll hold if anyone wants to ask some more questions. With that being said, let's get started. Michael Santaki, I give you the floor.
Good morning, everyone. So just some very broad background before we get started on our slides. Our goal here and what we want to do is sort of, you guys have all your daily tasks and functions. There's a myriad bunch of risks and exposures coming your way, from the slip and fall to what we'll talk about now, which is the fiduciary liability. And what we really want to do is sort of analyze and assess this risk in general terms, then boil it down to maybe its impact to our organizations, and then finally sort of look into how we can mitigate this risk, whether we can transfer the risk or whether we maintain the risk ourselves. So, in very general terms, the ERISA exposure is an extremely broad one. As you'll see, everybody can basically be called a fiduciary, and the exposures are deep with penalties and lawsuits and things like that. The good news here is probably twofold. One, you can transfer the risk easily and cost-effectively to insurance product. And two, for many of you not-for-profits, I think the overall exposure is less due to just the vagaries and mechanics of how fiduciary practices work. There is less concern for litigation, and the statistics will bear that out. So to get started, going back in time before there was an ERISA law, there were problems. Studebaker went bankrupt, the pension was underfunded, not much happened, people lost out. A labor leader in the 60s, George Barish, apparently diverted some union funds, went off into the sunset, no ERISA law. So, there was a burgeoning call for something to do. Surprisingly, and I didn't realize this, there was a TV special on pensions, a primetime NBC special, and back in those days, that meant that a third of the country was tuned in, all about pensions. So by 1974, there was a real need to sort of create a law, and that was encapsulated in the 1974 ERISA law that was signed by President Ford. So, what are the main components? What does ERISA do? First and foremost, there's disclosures. Plan information has to be disclosed, it has to be documented, it has to be made available. Second, there's a standard of conduct. If you are a fiduciary, you've got some rules of the road, which we'll get into. Third, and very important, there's now remedies, and there's access to federal court. So prior to that, most of these claims, common law, state courts, there was no federal remedy. And last, a number of entities were given enforcement rights to handle fiduciary plans, and that included not only the IRS and the Department of Labor, but the Pension Benefit Guarantee Court. So, a lot was done with this ERISA law, requirements of what you need to do as fiduciaries and employers, and, a whole new set of teeth for enforcement agencies. I will now turn it over to my friend Amari Williams, who will give us a little background into exactly what ERISA constitutes, et cetera.
So what is ERISA? The Employee Retirement
Income Security Act is a federal law that was created in 1974 to protect the assets placed in benefit plans. All benefit plans are subject to ERISA, including defined benefit plans, which could be pension plans that are funded by the employer, defined contribution plans, which are 401k or 403b, retirement savings plans funded by the employee and the employer, health benefit plans, which are primarily health, dental, eye insurance, and supplemental plans. ERISA sets regulations on reporting and disclosure of participation, funding, vesting, benefit accrual, fiduciary responsibility, and prohibited transactions pertaining to benefit plans. And the most important thing to know about ERISA is the law requires plan sponsors to provide adequate funding and guarantees payment of benefits on any terminated plan. So then we ask ourselves, who is a fiduciary? Fiduciary it can be any person who has authority or control over the management or administration of a benefit plan. Any one of the following falls into the category of fiduciary: plan sponsors or employers, executives, board members, natural person trustees, benefit plan committee members, advisors, financial planners, consultants, investment managers, anyone or any entity named in plan documents or responsible for reporting and responding to claims, anyone who hires or employs another person to be a fiduciary. And lastly, anyone could be a fiduciary. Now, Michael will discuss some of the key standards a fiduciary should adhere to.
So far, you know, we see that this law is very broad. Anyone can be a fiduciary, and it covers any plan. And by the way, when I say anyone, the courts have held that a board of directors who appoints fiduciaries, and that's all they do, can be held to ERISA law. So it's really anyone and any plan. There are 4 key rules and standards to fiduciary. One, you have to minimize your costs. If you're going out there and establishing plans and creating the proper documents and everything, you have to minimize costs. This isn't a boondoggle. You can't spend a lot of money doing it. You have to then invest in investments that will minimize the risk of a large loss. No hedge funds or limited hedge funds, you know, swaps and those kind of things are not really what we put into these plans. You have to act consistent with a plan document. So, you know, as we mentioned, there's a plan document. The plan document lays out a strategy. You have to act consistent with that. And lastly, and most important, is there's this conduct standard. The conduct standard under ERISA is a fiduciary standard. What that means is fiduciaries are required to exercise the same care, skill, prudence, and diligence that a prudent person familiar with such matters would exercise in managing similar affairs. It's basically the highest standard possible. You are judged against someone who is supposed to do exactly the right thing and know exactly what they're doing. That's the fiduciary conduct standard. Important to note that there are 2 absolutely prohibited transactions in the fiduciary world. One is self-dealing. Now, again, in some board scenarios, there are some limited opportunities maybe to do some of that, but with ERISA, there is no self-dealing. There is no personal gain. The other thing is you are not allowed to be a party in interest. You can't take a loan against the plan. You can't commit any of those type of transactions. They are prohibited on their face. So hopefully that was just a very brief, you know, outline of what the law is. And again, it's a very broad law. It's got strict enforcements, and it's got broad penalties and remedies in the federal courts. So I just want to briefly talk about some claim types that we've seen in our client base. A fair amount of claims over a denial or a change of benefits. And again, this goes either way, whether that person, the employee, is right or not. That's for the courts to decide. But there's a claim saying they retired and they were denied a benefit they thought they were entitled to, or there was a change in a benefit. We've seen a fair amount of claims, and these are expensive claims, when senior management leaves. Management comes in and feels that the old management shouldn't have gotten these large retirement payouts, and there's litigation on that. We have a client that's in probably $3 million now on something like that. There's errors. There's administrative errors all the time. There's incorrect benefit calculations, especially when someone else is hired to do an analysis of plans, and maybe there's a little error there and funds aren't made available because of that. There's garden variety misrepresentation. There's a wrongful termination of the plan. One of the big ones, especially after 2008 with the financial crash, was a failure to fund a plan. So, plans are funded over time with the expectation that they'll be able to pay over a certain amount of years, and if Wall Street doesn't cooperate, these plans will be underfunded. Going into the penalties under the ERISA law, there's two big issues that you have to be aware of. One is there's personal liability. As with board of directors, the personal assets of a fiduciary are in play in litigation. There are statutory imposed fines, so some of those bodies that I mentioned earlier, the IRS, they have a right to impose their fines. There are fines for failing to produce documents. Those are generally covered, by the way, but there are a variety of fines and penalties that come into the fiduciary world in addition to litigation. And of course, there are plaintiff attorney's fees should you lose the case. So just to go over a couple of claim examples and where the costs go up. What we mentioned before, administrative error. In one case, a plan administrator simply failed to submit insurance forms for an employee who just started, and within a week of their employment, they needed surgery. Because the forms weren't sent in, they had to pay. That was a $350,000 settlement. We have improper advice. We have one claim where an employee asked if he had to go to his HMO to get approval for a surgery. They said it wasn't necessary. That settled for $500,000. One interesting one, we had a claim where someone was stealing. It turned out, and I don't think the organization knew about it in advance, but that person was a relative of one of the employers of the organization, and that was a large case that settled for $2 million. And the last one, we don't see as much of these because most companies now have broad choices in their plans and they're outsourced to third parties that are large and do this for a living. But in one case, there was an excessive amount of junk bonds in a portfolio. And again, the key issue was the plan document didn't say that they were going to invest in junk bonds. That was a $2.5 million settlement and a $750,000 defense cost claim. So all these are fairly recent cases that have come by and come to our attention. There certainly is some litigation and some robust litigation in the fiduciary space. Again, the good news is that it is mitigated by some of the things we anticipate that you do in terms of sending out the plans, giving employees, a wide variety of selections. That probably reduces the lawsuits a lot. So some things we can do on the loss prevention scale of things. Certainly select qualified fiduciaries. They're out there. Make sure that you are not appointing fiduciaries that don't have a capability in this space. Meet frequently, and by the way, these are all sort of common sense ones, but hopefully they ring true, and if anyone feels a need to make a change, they should make a change. Plan documents should be reviewed. Meetings should be undertaken frequently. The board should be looking at this. Get qualified legal counsel. When something comes up, use legal counsel. Prompt communications. And lastly, and I think this is already kind of done by the way we handle plans, but encourage diversification. Most employers offer employees multiple plans with multiple, fixed income, stock, and a whole variety of options. That seems to be a very easy fix to reduce some of your litigation exposure. So, sort of, and again, I think we wanted to do this kind of briefly, but this sort of hits the halfway point in the discussion. We talked about the exposure, and I think it should be pretty clear that it's out there and that it's broad-reaching, and it could certainly impact a small not-for-profit. This isn't stuff that is just in the public company space. And by the way, some of you may remember years ago, public companies had a lot of litigation over public company stock that was in plans, and attorneys were using the ERISA law as an easier vehicle to sue companies versus securities litigation. But that really doesn't apply to our space. So what can you do now that you've at least acknowledged that, yes, there's broad exposures, there's far-reaching teeth on the enforcement agencies, and I do have a plan and I do have employees? So two basic protections, and this sounds similar to the D&O space, but you have indemnification, so any individual working for an organization should have indemnification in the bylaws that applies to them. Before anyone even buys an insurance policy, everyone should serve on an organization that provides indemnification for those who serve in good faith. the indemnification laws in most states and in New York are broad. They allow you to pretty much get indemnified for anything within the scope of the law. The second protection, and this is sort of, I guess, where we mainly come in, is insurance. And the good news here is there is a very favorable market for insurance, for fiduciary liability. The policies are generally non-expensive. They're less expensive than the D&O policies. Claim activity isn't huge. Again, in the not-for-profit space, it centers more around the benefits due and the denial of benefits and things like that. But again, we did have a multi-million-dollar not-for-profit case recently, and that involved former executives suing the new board. But again, insurance, the good news here is there is a vehicle in place to really transfer this risk onto an insurance policy for a very limited cost. So some of the highlights of an insurance policy, and again, we're always available to discuss this in detail individually as you consider either purchasing or renewing your policy or discussing the limits that you want to purchase. Claims-made policy, similar to a D&O policy, the claim has to be made during the policy period. It's not a perils wrongful act, and what I mean by that is that the policy doesn't list the wrongful act. It simply says any wrongful act in the handling and sponsorship of plans. Definitions on the policy are broad. Most policies will provide omnibus language that any and all plans are covered. The only thing that sometimes isn't covered and mostly isn't covered without scheduling is a multi-employer plan. But generally speaking, all of a single employer's plans are automatically covered on these policies. Most of these policies have a duty to defend trigger, which means that if you have a claim, the carrier has to defend the claim. The good news about that is if there's some covered and uncovered elements in the allegations, the carrier will generally have to defend the entire claim. And again, these policies cover the main breach of fiduciary duty and negligent administration. I mean, those are really the two areas you get hit on. A breach of duty, for example, you outsourced some fiduciary work to a relative, or you didn't give choices. Negligent administration, the more common, you simply forgot to add a new employee, or you didn't properly advise an employee about what they're supposed to do. There's a fair amount of those type of claims.
Hey, Michael, could you give us a 30 seconds more on the concept of a claims-made policy, talking about when the wrongful act happens versus when the claim actually comes in, please?
Yes. So because these policies, D&O policies, fiduciary policies, there's a certain sense that they don't get frequent claims, but they get the potential for severe claims. So what they want to do is they want to create a claims-made policy so that they're not, as an insurance company, on the line 20 years later for a claim that came in while someone had a policy. And I believe the general liability policies are written that way, right, or the property policies?
The property policies.
So these policies require the claim to be made during the active pendency of the policy period. So as long as you have a policy in force, if an act took place or a claim was made during that policy period, there's coverage.
Thank you, Michael.
So a couple of more coverage issues on these policies. Some key exclusions. What do these policies exclude? Number one, and chief among them, is the conduct exclusion, and that basically relates to intentional conduct. Any negligent conduct will generally be covered on these policies. What's not covered is an intentional fraudulent act or an intentional personal gain. Those usually require a final adjudication threshold, meaning that unless and until a court determines that you committed that act, coverage will continue until that point. These policies don't cover bodily injury. Again, multi-employer plans generally have to be scheduled. Some of the things you want to have on these policies, you want to make sure that your coverage is broad to cover fact-finding investigations, that you're not just covered at the subpoena stage, you're covered at an investigative stage. There's some voluntary compliance penalties that apply when you voluntarily sort of surrender yourself to the IRS and seek to have reviews. Those penalties are covered under these policies, usually up to a sublimit. Section 502 are IRS penalties. Also, they should be covered, and your policy should have coverage for all three of those. That's I, L, and C. And lastly, there's some HIPAA exposure on fiduciary plans. There should be HIPAA exposure for any privacy violation relating specifically to a fiduciary plan.
And now we'll discuss the key underwriting factors. And the million-dollar question is, what does the insurance carrier want to know about your organization to determine your exposure? Predominantly, the underwriters need to know what type of benefit plans are offered by your organization and the size of assets allocated to those plans. Does your organization have a pension plan or just a 403B or 401K retirement plan? Does your organization have 5 or 20,000 participants? Are your total plan assets valued at $50,000 or $5 billion? Another underwriting question would be, has there been a recent merger or acquisition? Or has a plan been transferred, which could mean sold or divested, or has a plan been terminated? Underwriters also need to know the financial condition of the sponsor and the plans. For this reason, they'll request the plan's audited financials and Form 5500s. What this will tell the underwriter is the status of the plan, how well the plan is funded, and will the plan be able to meet its obligations in the future. Applications will usually ask for a list of vendors or providers used throughout the management and administration of the plans, including investment managers, advisors, plan administrators, and benefit consultants. And finally, underwriters care if your organization has had a history of fiduciary claims.
So I will, just so I can sum this up kind of in 3 words, and we're coming sort of towards the end, 3 words to think about: broad, limited, easy. So what I mean by that is there's a broad exposure. There's no getting around that. ERISA law is broad. Anybody's a fiduciary. Any plan is covered. It is not difficult to bring someone into court under the ERISA law. And there's also penalties. There's a lot of penalties. It is a broad exposure. There's no way around it. Limited. It's limited in its application to not-for-profits. I'm not coming here to tell you there's a broad exposure and we all have to button up and double our limits. There aren't a lot of claims against not-for-profits in this space, and a lot of them are on the smaller side. There's no doubt about that. It is a limited exposure. And easy, what I mean by that is it's an easy risk to transfer. It is easy to take this exposure, transfer it onto an insurance policy, which will give you broad coverage for almost, I mean, these policies are almost modeled after the ERISA law. So there's almost nothing that's in the ERISA law that's not in the policy. So it's an easy transfer, and by price, you're mostly not paying over $1,000 per million of insurance unless you have a large or complicated plan or you're very underfunded. So it's not an expensive transfer, and it's a fairly easy process. So I think as you look at a takeaway from this, you think about that and you say, all right, there's a broad exposure. I've got limited exposure. These guys aren't scaring me so much, but there's an easy transfer. So to take it from there, I would say, by all means, any questions relating specifically to this or down the road to talk to Mark or Mari or myself about how you want to handle your specific exposure to this. But 3 takeaways are just, in my opinion, it's a broad exposure. It's a little more limited to the not-for-profit space, but, it's an easy vehicle to transfer to a third party. Omari?
So Michael and I have discussed ERISA law and what it means to your organization. We've talked in depth about who's covered under the policy and for what. We've also given you some thoughts on loss prevention, strategies, and risk management techniques. And last but not least, we've advised you on underwriting data that insurance carriers take into consideration when analyzing your fiduciary exposure. At this time, I welcome you to ask us questions in the chat box on the screen, or please feel free to contact us directly.
So we'll just hold a minute in case anyone has some questions. And we're looking at the screen carefully. Okay.
So on behalf of FOJP and Crystal and Company, thank you for participating, and please remember, anyone is a fiduciary. Thank you.